Good morning, Alan and Elise. Hope you guys are doing well. Thank you for meeting with me this morning. Hope the kids are fine and back in school and everything's going well for you. Um, Let me go ahead and get started. First, I applaud you for going through this process because it is very important. I know the information that I was asking for can be somewhat daunting and a little overwhelming. But I can assure you, I think you'll find it very helpful, and I think you'll find a lot of value in this. So we certainly appreciate it, and I think it's going to be very helpful. So let me get started. Alan, you asked me to cover what are your deficiencies for your estate, what would go through probate, and kind of explaining in general what the probate process is. First, I must state that I am not an attorney. I cannot provide legal advice, but I can cover your deficiencies and let you know what you may need to do to make sure the estate's in order. You do live in a common law state where you can hold separate assets. For instance, if you didn't live in a common law state, anything that was listed or owned in just one name is, regardless, it's automatically owned by the other spouse. However, because you live in a common law state, you can hold separate assets, which you may have intentionally have done that with some of the assets that you currently have. But we want to make sure that you're making conscious choices here because some of the assets that you do have are held separately, some for Alan and some for you, Elise. What the process is going to be is that upon death, property may be transferred at death in several different ways, often by a will or a trust, by contract or beneficiary designation where you list the beneficiary of certain accounts like IRAs and such, or by law, which is joint ownership. You have some assets that are held in both names, and hypothetically upon Alan's death, if it's a joint ownership, automatically goes over to Elise and vice versa. Property that does not go through will, trust, beneficiary, or joint ownership will be distributed at death to state laws, through state laws. One of the most common ways you can ensure that everything will go through in order is by creating a last will and testament. I would highly encourage you at minimum to set up a will. What this is, it's a document executing in accordance with legal formality that enables the person executing the will to transfer property upon death in a manner that you desire. Some of the advantages of holding a will is you can name an executor, and we'll talk about that here in a bit. You can designate a guardian. Personal property, you can be specific about which property goes to whom. And you can also create what is called a trust, which can be created upon death, and we'll get through in a little bit more detail here in a bit. There's some disadvantages, however, with everything going through probate, and for lack of a better term, a will ensure, or the probate process is basically the process of executing the will. There are some disadvantages of that. Is that one, there could be some cost with attorneys. There could be a delay in getting the assets to the people you want to wish those assets to, and it's public. It's a public process to go through. Based on the current assets that you have, Alan, you have $249,950 as of the date of the information you gave me that will go through probate. To be specific, we're looking at the First Mutual Growth, that ML brokerage account, Alan's truck, and the fishing boat. And also, you have a life insurance, policy B, where you have the estate listed as a beneficiary. And I talked about that in your life insurance notes, where I want to make sure you made a conscious choice to do that, or there's other options you can do. But that will ensure that part of the life insurance, the beneficiary, is the estate. So just make sure you're aware of that. Elise, I also kind of just ran it through for yours. The education fund, your investment portfolio, your car, and the full fur and jewelry It's about $263,000 based on that. The $263,000, or I'm sorry, the $210,000 and $22,000 education fund, those might be a little bit more complex because those came from the life insurance proceeds of your previous marriage. Now, I understand there's a little bit of a complex situation with the children, Jerry Jr. and Christopher, not getting along so well with you, Alan, for various reasons. And I know sometimes that can be challenging, but that makes the issue a little bit more complex. One of the things you might want to look at is perhaps a Q-tip trust. And what that does is that a Q-tip trust will leave assets to the surviving spouse, and then upon that surviving spouse death, then it will be passed along to the children. Another option you can do is what is called a testamentary trust, at least where that is created upon death, and the proceeds can be managed by a trustee for the benefit of the child. Those are just a few of the options. I would certainly recommend that you seek legal advice and make sure that we go through that process. But at least you're aware of some things that you might be able to consider. The other option simply is that if you want to leave all the assets to each other, or specify any individual assets that you want to list to each other, you can list what is called a transfer on death or a payment on death. A transfer on death is in essence the beneficiary for non-qualified accounts, like an investment account, like the investment portfolio or the brokerage account or a mutual fund. You can list a transfer on death where upon Alan's death, hypothetically, it goes over to Elise without having to go through probate. A payment on death is basically for bank accounts, same thing. Or if you didn't really intend to set up these accounts individually, you can always just create a joint ownership where upon death it automatically goes to the surviving spouse and it avoids probate. So certainly something to look at. With regards to the children, what to do upon death, I would highly encourage you to name a conservatorship or a guardian for the children. One of the options, you mentioned Sarah as a beneficiary. Instead of listing Sarah as a beneficiary of the assets, you could just name her as the conservatorship or the guardian. That would mean that she's a fiduciary for financial purposes and basically just to manage the personal care and the well-being. They are two separate roles, but she can be the same role. It's certainly something to consider. Lastly, I would also recommend that you look to set up a power of attorney. What that does is basically it's a medical proxy. Basically, it's bringing in effect that upon one of you being incapacitated, it gives the power to the other to make those decisions for healthcare choices. An advanced medical directive is certainly another option. This provides for suspension of medical care if a person becomes terminally ill, as determined by one or more patients. But that's something, all of this data, I would recommend that you seek legal guidance and follow through the process of an attorney. But I just wanted to give you some information to consider, and I hope you found this helpful. All that being said, I certainly appreciate your time. I hope you guys have a wonderful day. If you have any questions, please don't hesitate to call, because I know we talked about a lot of information, and this will be provided in writing too, of course. Thank you. Have a wonderful day.